close of our presentation today. So we noted that there are certain aspects that are not covered in the bill, certain areas that we felt were very important that have been left out. And we cover that under the recommendation on areas not covered by the bill. That's on page 7 of the legal memorandum. And one of them that we noted is the provision for anonymous marriage dissolution proceedings. Something to notice about divorce proceedings is how explicit they are. Usually the media is quite involved in these proceedings, and there are liabilities in this back and forth, and we want to say that it's usually the children. So much is put out there. There is disclosure of sensitive information regarding properties, businesses, bank accounts, places of abode, sometimes even people's HIV statuses. And such disclosure actually leaves the concerned parties exposed to the numerous risks. This particular bill mentions one of the principles it wants to uphold is the best interests of the child principle. And we agree with that children should be protected from the mistakes of their parents. They do not have to pay the price. So the law should provide an alternative for anonymous marriage dissolution. And this has actually been taken up by certain jurisdictions. For example, Kenya, in the case of PNN versus ZW, and this was cited in approval in one of our, in our courts of law in the case of Ambayo versus Aserua, in that if someone is to go to court, can we have the alternative of them using their initials instead of their full names? So that, for example, if, God forbid, my father went through a divorce petition some years, and I go to law school, and I engage in student leadership, then, for example, you Google my name, I'm not attached to whatever happened between my parents. So I think the law should protect its children in this particular way. Yeah, in that, and this also is provided for under Article 27 of the Constitution. It provides for the right to privacy. I think parties that opt to go to the courts of law to separate legally should have that alternative. Reinforce it's a constitutional right provided for in the Constitution. And our recommendation, therefore, is that a new clause should be added to the bill to provide for anonymous proceedings, allowing parties to use initials. And this is not far-fetched. It's usually done in cases involving children, so it can be applied in this particular bill, left to the election of the parties. A second recommendation we'd like to make is,
if I should just supplement on proceedings, first of all, I would like us to now consider, she has discussed the child best interest, I would like us to discuss the adults themselves. Right now in Uganda, we are looking at a lot of internet fraud. Someone will call you and tell you, I need 10,000, MTN, Airtel, there is so much fraud constantly. But then we look at the fact that when your private information is out there, in marriage proceedings, we have to divide property, we have to divide assets, there is matrimonial property, there is a lot of conflict, which is very public. So when actually the marriage is dissolved and we are now going through the proceedings, we look at the fact that these people's property are put out there. We have a right to privacy under the Constitution. And if my property, my bank details, my HIV status, my sexual life in divorce is actually put out there, there is evidence on cruelty, violence, adultery, and even now adultery, the correspondent is part of it. We are petitioning that it becomes private. The marriage institution is sacred. It's celebrated in church. It is in the Bible according to the Christian denomination. It's celebrated as an institution for two people. So we do not think that it should now be, when it's actually annulled, it should now be a basis for everyone to have a say, to have, oh, so she has property here, she has property there, these are the children. Why should my name as a child be involved in my parents' divorce proceedings? And other than that, me as an adult that is separating from a gentleman that I chose to marry before, it should not be business of any other people. Weddings, we get the chance to actually invite we have guest lists now. I invite only the people that are close to me, that are my family and friends. So in divorce, why should it now be a matter of state? We get precedent. Case precedent is very important in legislating and giving us progressive law. But we can actually also get that. We can get the principles without necessarily giving the gothic and cruel details of that marriage and those persons, because by the time they consented as two persons to marry, then they did not actually say the state shall now know every single detail. So we recommend that this bill for anonymous proceedings, we recommend that we use initials ZWN, AI. It's better than someone's details. Repute. When I'm being hired in Kampala, you are not hired on, someone will Google you, oh, her name is Adikin Mary. I'll just put on Google, what is she? I can say she's a chairperson of Makerere Law Society. I can say she has contributed in this and that. And then I see, oh, she was in a divorce. She cheated. She did that. We are a constitution. We are a country that's based on repute. How the society perceives you is very, very important. So marriage and its dissolution should actually now be left to those parties. Because if I'm Googled or if someone looks me up and they get those details, even as an adult, I did not consent that in the judgment the judge puts all these details to prove that maybe the marriage has come to an end. The different grounds, maybe the cohabitation or cheating, all these should actually be secret, should be private. So that's what we...
Honorable members of the committee, simply put, we are saying that divorce should not be the death of individuals in society, that they should have life after they part ways. Moving on to our very last recommendation in our memorandum, which is the consideration for indigent in marriage dissolution matters. Simply put, that the law should provide for people who are not financially up there. Currently, as divorce proceedings stand, it has been noted by Justice Mutangula in the case of Ambayo versus Asero. We keep on citing that because it has been cited in the memorandum of this bill as one of the most progressive decisions of our courts of law. And one of the things he notes is that divorce proceedings take a lot of time. And the more time you spend in courts, that's more money that is going, a lot of money. And how many Ugandans can actually incur those significant legal fees? The majority of Ugandans cannot afford that. So can the law provide for an alternative for individuals who cannot go through that lengthy process of the courts of law? This bill is very important in that it consolidates all different types of marriages. We have customary marriages. So can the law provide for that? We have Clause 62(1) of the marriage bill vests the power in the registrar of marriage, and in that he traditionally facilitates legal marriage. Can it also vest in him, for example, the power to look into some of the aspects of dissolution of customary marriage? And under there, we recommend that the bill provides for alternative avenues for dissolving marriages, and this is particularly customary marriages. This provision could be particularly effective in customary marriages where persons of a low income status contract.
Thank you. On the same, would like this, as we are drafting that, you could look at the civil small claims. They have a proper procedure on how someone can actually, a person be able to lead court and say, I demand this person 800,000 without legal representation, because it's already being done in our courts under civil law. So it can actually now be adapted into family law. So because when someone does not have legal representation and then they are poor, what then happens when they want to end their marriages? A lot of these women are in marriages where the husband is the head of the household. He has the say, he provides, which is all right. But then what then happens to her when she wants to end the marriage? So we recommend that the ordinary man who cannot lead evidence, who cannot draft a petition, because dissolution of marriage is by petition and evidence thereunder, we pray that the committee will consider at least a sort of small claims for the poor people, because Uganda as a whole, we have the elites and the other people, and both of those people deserve equal rights. The Constitution puts us on the same pace. So we pray that as this law is being drafted, both of these persons will be considered, especially the indigent, because they do not have the resources, they don't have the legal capacity to have legal representation.
Okay. To conclude, honorable members, first of all, say that we hope that none of the submissions we've made here today give you the idea that we want to disrespect the institution of marriage. There is a reason why this particular institution has subsisted through all the years, and it has stayed. It's a very important institution in the framework of the state. But what we hope is that the regulation of this particular institution, and even at the dissolution of marriage, that we have a progressive legal framework, that we have a framework that actually provides for all the elements, so that you're not pushing courts to legislate. That has been that has been one of the biggest challenges that has been noted, especially when we are dealing with marital matters, in that the legislators take a back seat and they let the courts legislate. So we hope that this committee takes on the mantle, and we look forward to hearing from you. That has been the presentation from the Makerere Law Society, from the 5 students before you. Thank you.
The law school did not pick interest in the points you raise, that we shouldn't now invite them to scramble for an opinion. We don't want to assume that other stakeholders who will submit subsequently won't have what to say in that regard. So we would perhaps abide by their conclusion. I think you make a very impassioned presentation. First and foremost, I listen to you with a lot of pride. I'm a student of the Makerere Law School, working on my LLM research, and I see you, and I think that you represent very well what Makerere Law School stands for, very brilliant minds. On the points you raise, I can't agree more when it comes to the idea of I took note of where actually the bill, as if the bill assumes the idea of premarital counseling, it would be as if the bill assumes that Ugandans at the age of 18 are not mature enough to make contractual commitments. If you think that someone at 18, owing to the Constitution, is old enough to buy a house, buy property, assume legal liability, etc., how do you think that when it comes to them deciding on who they should marry and when, that they don't have the ability to decide without the intervention of premarital counseling? So I just wanted to highlight that for me is really on point. I hope that other stakeholders will agree also. I wanted to respond to Council's submission. Council, I wanted to distinguish that this committee is not the mover of the bill. There is a mover of the bill. When you talked about legislating with the mindset of our constituents, where we come from, I wanted you to know that we are alive to that, and we did not move the bill. There is a mover of the bill, and the concerns you raise also touch.
We are here to share ideas and views how to come up with a good law, but to put it clear, we are not the movers of this bill. My concern is on clause 89, as you have tried to give in your views, and you said we should delete it completely. Holding out as though married. For instance, we are panel bit, or we are sharing ideas. Like if we have tax policies in Uganda, people start their companies but don't want to give taxes. So you have to come in so that policy is implemented. Like we pass this bill, we call it marriage bill, but it doesn't have a clause so that that this bill is implemented, that the people can go for marriage. That this clause is trying to implement or to to put there the enforcement of this bill. So we are here to share the views. Don't you think that the mover of this bill wanted to enforce so that people can go for marriage? Or maybe you can put there incentives that when you are married, or you don't pay this tax, or you get this from the government, so that people are encouraged. Because this clause try to encourage people so that they go for marriage, so that they can get married in whatever a type of marriage, so that they can legalize their marriage, so that they can enjoy what is in marriage. Don't you think that we, instead of deleting it or expanding it from the bill, we put their incentives so that we encourage people to get engaged in a marriage? And lastly, it is in that line, that because that's what you have presented on, and that's where I found you presenting, and that's where I wanted you also to think about in that line. How can we enforce this bill? You can pass it, but will remain redundant. People be there, don't want to get married, but we need to encourage them how they can get married. Thank you.
An offense to incentivize people to marry. A marriage institution is entered out of consent. It is entered out of one's volition. You don't compel people to marry. So if that is the mind behind legislation, and of course that would be drawn from what the mover intended, that would mean that Ugandans are being compelled to marry. However, we acknowledge the fact that people have the right to love, the right to unlove, the right never to love. So they have the right to marry, to leave the marriage, and never to enter the marriage. So you cannot put a clause, and even by way of a criminal offense, so that people marry. To me, that, and then the other thing is that you don't encourage the good thing by using something that is detrimental to the societal approach. In the end, it will create a bad perception about marriage. People will just enter institutions of marriage because they have to. Now, imagine an instance where someone, yes, they were married, but then they divorced, they are no longer married, meaning they are no longer enjoying rights that accrue to the fact that you are married. So are you going to force that person to look for another partner so that they, if it is an issue of taxation, if it is an issue of there are institutions where you cannot go when you're not married because of their policies, are you going to compel someone to marry so that they benefit from that? I think the reason behind our recommendation that, and that's why we were express, we did not want to go through corners. We said delete the whole clause from the bill. We were intentional because, one, what is the negative implication of not having this clause? Is it there? And then what is the positive implication of having it? The argument of the positive implication now causes compulsion. So in our opinion, this clause somewhat, whereas might be grounded on some moral standards, per se, let me say, if they are Christian standards, that they desire that people be wedded, and of course that would be even subjective to Christian denominations. There are Christian denominations who will interpret what marriage is under the Bible, not to include aspects of registration and all those things, as long as they do what Jacob did before the uncle, the agreement, and then he fulfills and satisfies what is required. He works for the 7 years. That is a marriage. So I think it should be on the let us look at it on the negative implication. There is a very big scope of the population that is going to be affected. People who are now in marriages, okay, not marriages, but in institutions that would call a semblance of a marriage. On the other hand, this bill has been so progressive that basing on the decision in Chigongo, Olive Chigongo versus Chigongo, where there was an issue of someone who has been in a marriage for quite a long time, okay, in a cohabitation. But then the issue arises before court. Do they have rights, for instance, attendant to property rights? Can children benefit from rights that are a semblance of marriage rights? So when this bill becomes progressive under clause 61, providing for such kinds of arrangements where people now under this 1889, it would be criminal. In my opinion, if you now bring 91, it would be counterproductive against 61. So 61, you're now progressively protecting the children born in such an arrangement. You're protecting the maybe equitable interests that would accrue to people living together, maybe doing business together, and so on. So I would still stand with my colleague's position on this clause that we repeat it. Thank you.
May I ask my namesake that...
Is my colleague mentioned that we recognize that marriage is a social institution, it's a political institution, but it's also economic. And the question of how will you attract people to marriage, for a lack of a better word, I think the bill is progressive. For example, you mentioned the provision on matrimonial property. We did not address our minds to it because we felt it was exhaustively covered. By the bill going ahead and citing a progressive case in the memorandum, yes, we found that very progressive. Asarua versus Ambayo cannot be underestimated. We spent half of our family law studying that and recognizing the irretrievable breakdown of marriage as a sole ground. So the institution of marriage has been made lucrative. At least we can speak for young people in that property rights are protected. We have instances of presumption of marriage protecting the children, the rights that children can enjoy, property rights. Yes? So we feel like if Parliament takes a front seat in this one, particularly in regulating marital relations and dissolution, and not taking a back seat as it has, and letting the courts do the legislation, that is a strong position. This bill has had a very long shelf life. It has had very many names: domestic relations bill, marriage and divorce bill, and now finally the marriage bill. The names keep on reducing, I think, to make it palatable to the public. So it's our prayer that this bill actually passes and that these different recommendations that have been made are adopted. In case you'd like to hear from us, as a Makerere Law Society, we are open. Our exams ended yesterday, so this was in a short period of time we're able to come up with that, but we look forward to interacting with you more. Thank you for giving us an opportunity to contribute to the legislative process in this country. Thank you.
People, you have done so.
Amanya gange bampita Kankwasa Isabel, nsomera Makerere, ndi ku law school. Lero twabadde tuli ku parliament nga twogera ku marriage bill. Eno bill eri ku bantu abagala okuwasa, so twabadde nga twogera ku bintu ebibakwatako nga okutuula wamu nga tonnaba kuwasa, ng'ekirala nga omuntu bw'obeera ng'omukyaye amaka, ebintu, abaana, byonna ebyo bye twabadde nga twogerako leero. Twabadde nga tugamba akakiiko nti mbu twagala first of all omuntu abeere ng'ali bw'obeera ng'ayagala kuleka munne, it can be private, nga talina mugamba nti buli omu ng'abeera mu business. Ebirala twabadde nga tugamba ku kintu ky'abaana n'ekintu ky'amataka bw'abantu bwe babeera nga baawukana. So twabadde nga tugamba komiti kwate ku bintu ebikwata nnyo ku bantu aba bulijjo ng'okutuula wamu nga tebannaba kuwasa. Komite bill ebadde egamba nti mbu bw'obeera nga tonnaba kuwasa awo nga bakutwala nga ebeera criminal offense. But kati twabadde nga tugamba komiti nti mbu tebeera criminal offense, tebeera nti mbu wa kintu ky'amateeka, lwakuba ekintu ky'okuwasa kibeera nga kya buli omu bw'abeera ayagala kuwasa owasa, bw'obeera nga toyagala nga towasa. Ekintu kya cohabiting bill eno yakikutteko n'egamba nti mbu bw'obeera omuntu nga okahabitinga nga mwagala kukyuka, nga mwagala kudivorcinga, oba nga omuntu tewamuwasa but mutuula wamu nga kati toyagala tutuula naye, bill eno ekwata ku bintu nti mbu abaana bajja bate mwenna mwembi mujja kulabirira abaana n'abazadde nga maintenance yeri nga omusajja asasula school fees n'oba omukazi buli omu abeera ng'alina sente z'okulabirira abaana abo. Eyo position eya cohabiting nti mbebeere crime, tugamba nti mbu teri crime. Omuntu bw'abeera ayagala kuwasa awase, bw'abeera nga tayagala kuwasa tawasa, lwakuba tekiri nti mbu kati bw'otawasa n'obeera n'omukyala bagenda kutwala mu prisons. Kibeera nga kiri up to someone ebeera nga eri consent tetuyinza kugamba nti mukati etteeka liriwo omuntu bw'abeera nga tawasizza bagenda musiba.
Hello everyone, my name is Annie Maria Adikin and I serve as the President Makerere Law Society, and today with a group of 4 people, we're a group of 5 students from Makerere School of Law. We're here to present before the Committee on Legal and Parliamentary Affairs on the Marriage Bill 2024. The history of the Marriage Bill has been quite controversial. It has had a very long shelf life. From the 1980s, we failed to get a bill that addresses issues to do with marriage and dissolution of marriage. So today our conversation basically stemmed on certain areas in the bill that we feel need to be polished. One of them is cohabitation. My colleague has spoken on cohabitation in this country, in that we have so many Ugandans that are not legally married. And one of the things that the bill does is criminalizing, in that if you're just cohabiting with a person, which is that if you're not married to them according to the law, then there is a punishment. The police can arrest you for some of these things. We felt that is not okay, in that that's a law not reflecting society. Another thing that we saw was worth talking about was the issue of compulsory marital counseling, the premarital counseling. The bill provides for different types of marriages. We have the customary marriages, the Christian marriages, we have the civil marriages, the Hindu marriages. So by putting a compulsory element of counseling, first of all, by putting a compulsory element of counseling, it's assuming that everyone is in a Christian marriage, because that's an element that is very peculiar to Christian marriages. So that's something we felt, we see that it's a good initiative by the legislators, but making it compulsory is it's a bigger impediment into people wanting to enter into marriage. Another area of concern that we had in the bill that we recommended, that was not provided for in the bill, is the issue of anonymity in proceedings, in divorce proceedings. Yes, in this country, divorce is usually a very ugly matter. It's all over the media, and the victims in those divorce proceedings are the children. So can we have a law that protects the children? Can we have the option of, for example, parties that go to court to divorce using initials, so that if I'm to go for a job somewhere, someone is not going to search online and find that, oh, I'm the daughter of so-and-so who divorced at this particular time. So we are saying that divorce should not be the death of individuals in society. Those have been, among others, those have been some of the recommendations that we've made in the conversation we've had before the Committee on Legal and Parliamentary Affairs today. The issue of cohabiting, what we are asking the legislators to do is to be honest about the people that they represent. The majority of Ugandans cohabit. So what does it mean if legislators make a law that actually sends more than 50% of Ugandans in prison? Is that a realistic bill? And those have been some of the challenges that we've had with the bills that have come before. It's not realistic. We want a law that applies to Ugandans. The state has no business, for example, criminalizing cohabitation. Leave couples, leave parties who want to enter into marriage with all its benefits. Leave parties who do not want to enter into marriage to not enter into marriage. Do not criminalize it. That's a state taking, the legislators taking another, it's a backhanded move, and as a students of law, we could not let that happen. Now, the traditional understanding of civil marriages has been that when someone thinks of civil marriages, you somehow automatically think of the Christian setting. So I think by the legislators bringing in the issue of potentially polygamous, something that we highlighted is that they have to put the option of monogamy too, because the clause says civil marriages shall be potentially polygamous. And if you're to read, for example, the Customary Marriages Act, it's where that wording was, we first see it in laws in Uganda, potentially polygamous. And we see the same thing being adopted for civil marriages. So the legislators should include monogamous marriages. And then potentially polygamous can stay, for example, for customary marriages, because we acknowledge that in the customary setting, marriages can be polygamous. Yes, so I think that's it's commendable for the legislators to try and envisage, provide for a law that actually reflects the realities of the society of Uganda. However, they should provide for the element of monogamy, so that people do not automatically think that civil marriages automatically become polygamous. Yes.
Well, the bill has a clause that says the minister can recognize other religions. The challenge is that for these religions, the 4 which are in the bill, it has been provided so much in detail. So are we giving the minister legislative powers equivalent to parliament legislation, that when he's recognizing other religions, he will provide for that? That is likely to be a challenge, and hopefully the bill is not challenged for being discriminatory or against the Constitution. That said, the contents of the bill, we begin with the clause 5, which is defining marriage as between one Christian man and a Christian woman. And our challenge is that it does not recognize the fact that there are non-Christians who have gotten married to Christians, like a Christian man marrying a Muslim woman in a church, or the reverse. So that can be considered to be discriminatory. We are proposing that we should stand by the present position, where for as long as one of the parties is a Christian, all they need is the other party to follow the Christian teachings. You don't need to change your religion. That's why today, maybe an Anglican man can marry a Muslim woman in church. Also, if the bill provides for this, what happens to those marriages already conducted? That's one of our issues with that definition. The other issue with that definition is it says this marriage is for life, which suggests that the bill does not recognize, for Christians, does not recognize divorce. And yet the very bill has an aspect of divorce. So we are suggesting the aspect of for life get deleted from the bill, such that we define it as a union between a man and a woman without necessarily saying it's for life, because we know divorce is a reality that people will face. I'll skip free consent for the interest of time. Place of celebration of marriage, that is in clause 18. It says marriage shall be in open place licensed by the Register of Marriage. What we find problematic with this, it can apply to Christian and civil marriage, but it may not apply to customary marriage, because is the registrar going to license every home where a customary marriage is going to be conducted? Because if we are saying every marriage should be conducted in a licensed place, it means even customary marriages, we are going to have those places licensed. The same applies to Islamic marriages, because Islamic marriages as it is today can be conducted in homes. So is the registrar going to issue a license for every home that is going to have an introduction or kwanjula or whatever they call it, or for every home that's going to have, I think it's called nikah for the Muslims? We find that problematic, and we think it should be an exception to Islamic and customary marriages. Then clause 19, celebration of marriage by licensed registrar, requires that the registrar shall celebrate every marriage. Whereas this can apply for all the other marriages, it may not apply for customary marriages, because under the bill, the Register of Customary Marriages is a sub-county chief. Now, look at a situation where you are having 5 introductions in one sub-county, and the bill is saying the sub-county chief must attend each of them. So is it possible for the sub-county chief to attend to each marriage happening in the sub-county? We find that practically not possible. Besides, the sub-county chief is actually not a traditional leader in any way. So we don't know the reason why. We believe the bill, once the bill requires the notice, which is given to the sub-county chief, and the registration, which is given after conducting of the customary marriage, which should be conducted according to the custom of that community, which is already in the bill. There is no need for the registrar to be physically present at each and every customary marriage. Then clause 21 on marriages in Ugandan embassies and consulates, which we think is a very good clause because it eases issues of marriage for Ugandans who are in diaspora. The only problems we have with it is when it comes to customary marriages, does the embassy become a home of someone so that an introduction can be held in that embassy? Maybe this could apply to only civil and the other religious marriages without necessarily applying to customary marriages, which need something special about the custom of the community which is conducting the marriage. That is one of them. The other thing is that if you give a notice in an embassy, the purpose of the notice in all marriages is to notify people that X and Y are going to get married. If you have any reason, please come and challenge. Now, the way the bill is, I can leave Uganda, go to Kenya, give a notice at the embassy, fulfill all requirements, and get married there. When I'm trying to run away from impediments in Uganda, maybe I'm already married in Uganda, or maybe there's a reason someone should have given. So we feel the notice in embassies might need to be, a copy of them must be given in Uganda, maybe by publication in a newspaper, or given a notice through the registrar or registrar general, such that even people who are in Uganda will get to know that Peter and Mary are getting married in Ugandan embassy in the UK. Otherwise, if no notice is given in Uganda, there is no way people who should be objecting to this marriage, in case there is any reason, will get to know that that happens. We also think, to avoid a situation where I just wake up today, run to Ugandan embassy and give notice and get married, we think the law should introduce a condition. You should have lived in that country for whose embassy you want to marry for a specific period of time, might be 6 months, such that we know you are a resident of the UK, you are a resident of Kenya, as opposed to being you a resident of Uganda, and because you want to run away from one thing or the other, you run to Kenya and get married there using Ugandan law. Then clause 22(2) on certificate of no impediment is a bit ambiguous because it provides that once the registrar issues a certificate of no impediment, it should be proof that there is no marriage between the person who has that certificate. The dilemma with this is it does not recognize polygamous marriages under the very bill. Because if you say, if I have a certificate of no impediment, it shows I'm not married, but I could be married under a potentially polygamous marriage, and I need the certificate of no impediment to conduct a second marriage. So the way it's framed as if it only applies to monogamous marriages. And yet the bill covers both monogamous and polygamous. So we think this clause 22(2) should be redrafted to cater for also polygamous marriages, and where someone is in a potentially polygamous marriage, the certificate should show that this person is in a potentially polygamous marriage, and not as proof that there is no impediment, but as proof that this person is in this arrangement. So if this person wants to conduct another marriage, because when you look at the law right now, I could be married and I want to conduct another marriage, I'll pick this certificate and pretend I'm not married because the law is saying it shows you're not married. And then go ahead and marry a second person. Then a substantive objection has been made. The bill is silent on what the registrar or the court can do on objection of marriage has been raised. There is need for the bill to provide for immediate actions, mid and long-term action. For example, where there is evidence that there is genuine reason that the registrar may investigate the matter, where someone raises an objection for celebration of marriage, the marriage should be stayed. So right now, the bill allows someone to object to a marriage, but it does not say, if I object to a marriage, what does the registrar do? Does he investigate? Does he go ahead? What powers does the registrar do? So we are recommending on this particular one to give the registrars powers to investigate a complaint, including powers to look into evidence and make a ruling. Let's look at how it happens. There is where someone objects when the two parties are before the registrar, and the registrar says, does anyone have an objection, or forever hold your peace? And then I raise my hand, I say, I have an objection. So when I say I have an objection and here is the objection, what does the registrar do? Maybe the registrar should stay the marriage, the wedding ceremony, but shouldn't stay the wedding ceremony just because Peter has said, I have an objection. There should be some standard. So when I say I have an objection, at that moment, what do I need to show such that the registrar might say, yeah, you have a point, let's look into it. So it shouldn't be just an objection. So the law needs to set those parameters. And also, so the parameters should be short term. For example, if I say, I have an objection, here are photos of the wedding that Peter conducted with another wife. So when the registrar looks at the photos and indeed it's Peter who is before him, he can say, maybe we are staying this to do an investigation for the next, maybe 1 week, because we don't want to be at the detriment of these people. We don't want people to abuse the objection, but at the same time, we want the objection to work where someone has something genuine. So we need to give it time where you can set it aside and then object. But we also need the long term, because sometimes within the week, you may not have gotten the evidence. So what happens in that situation, we also need to give it time. And this objection should also be available both to court and to the registrar, because what if the registrar ignores my objection? Maybe I should be able to get a court order to stop the wedding from happening. On marriage districts, there's a bit of confusion in the law, because under clause 30, it says they will declare marriage districts. But under clause 31, each district administrative officer is a registrar. So if we are making each district administrative officer a registrar, why don't we straight away declare every district a marriage district? Because why do we have to leave it for the minister? So is there a situation where there is a district without a cow, and so there is need for the minister to say, now for you, since you have no chief administrative officer, you will belong to this district. We feel just to ease the administration, let's declare every district a marriage district, since we've declared every chief administrative officer a registrar. Under clause 34 and 35, it requires submission of marriage particulars, which should be submitted to the district registrar and the registrar and the chief registrar. We think there's some sort of, maybe it's poor drafting. Instead of using marriage particulars, these are actually returns. like it is in the present law. So the present law, you don't submit marriage particulars. Particulars would require something like name, date of birth, sex, father's name. All those will have been covered in the notice and in the certificate you've issued. So let's just provide for filing marriage returns on a monthly basis, like it is even in the present law. Registrars submit marriage returns to the Chief Registrar of Marriages. So you submit on a monthly basis without, because when it goes into marriage particulars, it gets a bit confused. Then there's also clause 37, which says the access to the National Marriage Registrar. Clause 37 places the National Marriage Registrar under NIRA, under NIRA, and NIRA is under Ministry of Internal Affairs. When you look at the bill, this bill is under Ministry of Justice. So you are having two sort of departments. We feel it might be hard if the registrar is one side, conducting the marriages, reports to another ministry, and then there is another ministry which is handling the certificates. Let all marriage registers, national marriage registers, be in the custody of the Registrar General of Marriages. So we don't care which ministry he belongs. Registrar General of Marriages has all the registrars. That will ease. Whether they place the Registrar General of Marriages in a NIRA, whether they place him in a gender, name it, that's where the custody of all the registers will be. That will ease administration of this. Then, under clause 37, it restricts access of this information in electronic form. We find this problematic on many fronts. One is that under the Access to Information Act, which enforces Article 40, I forget the article of the Constitution, it is you access information in any format that you are able as a citizen to use. So there can be a citizen who is unable to use electronic formats. For example, the blind. They may not use electronic formats. So when you restrict that they will access this information in an electronic format, you're not catering for their needs. So we feel, let's not restrict the format for which this information in the registrar should be accessed. We can allow this information to be accessed in whatever format. The details of how it's accessed, we leave it to the registrar. For example, when you look at the Access to Information Act, it allows you to access information in whatever format, but at your cost. Say, for example, if now there is need for, is it called Braille? I forget the name. Braille. So it's your cost. You pay a charge to turn that information into what you can read. And so that enables everyone to get the information. There is clause 38, which says non-registration of marriages does not invalidate the marriage. Well, we understand where we are coming from, that we are coming from a society where many people are not educated and all that. But then, in today's world, this clause sort of removes powers from everyone. Because if my marriage is not registered and it's okay, then what's the purpose of others registering it anyway? So we think all marriages should be registered. The law which provided that it's okay for marriages not to be registered was made in 1904. At that time, not many Ugandans were educated, they couldn't access many of the registrars. But now we've made a sub-county chief as a registrar. We've made a church or mosque priest, imam as a registrar. So I don't see a situation where someone can't access the registrars. So why should we not register all the marriages? And this is important. It's important that because at one stage you'll need this evidence. And if you don't register it, it will be very difficult for you to get the evidence. For us, we think this should be forced. Under clause 39, conversion of marriage, it does not provide for the effect of conversion. And it also does not provide for change in the registrars. So, two things here. If I change from potentially polygamous to monogamous, the register should reflect that I have changed. If it does not, it means I will change and still go ahead and get married, and it will still be okay. So what we are proposing here is, if there is a change, let me say you are changing from potentially polygamous marriage to monogamous marriage, whoever is doing it, because under the bill it's done at sub-county level, it's done at registrar level, at lower levels. But the chief registrar may not get to know that in sub-county Y, Peter changed from potentially polygamous to monogamous. That means if that information doesn't come to the national register, Peter will move to the next sub-county and get married. And the clause, the purpose of this clause, which is to protect those who want to be polygamous, remain polygamous, or those who want to be monogamous, remain monogamous. In other words, I can conduct an introduction, which is customary marriage, and tie it, make it monogamous. Now, if I tie it and make it monogamous, I should be able to inform the Registrar General that my marriage, despite it being customary, is monogamous. If we don't inform the Registrar General, then one of the parties can move to the next sub-county and get married because there is no record to show that this was done. We also feel that this change of marriage is a bit of complicated legal aspect, which shouldn't be left to sub-county chief or religious leaders, with all due respect to religious leaders and sub-county chiefs. We are now talking a bit of law. You are changing from one contract to another aspect of the contract. If you leave it to someone who may not understand issues of the law, it might be abused. That's our thinking. That's why we were thinking, let's change in marriage, monogamous to polygamous, polygamous to monogamous, be done before either the chief registrar or a magistrate, who will, because when you look at the bill, they set some standards, free consent and all that, who will inquire into those legal issues and then make it happen. On clause 40, impotence and vaginismus, which are diseases, are made as grounds for void marriages. We feel it shouldn't be the case. They should be made grounds for voidable marriages. Because people can decide. The man is impotent and he says, me, I'm married to an impotent man, and it's okay. My marriage is okay. So let's not force that one who makes that kind of decision to say your marriage is void because the man is impotent or the woman cannot engage in sex. So we can move that clause and make it an issue of voidable marriage, which means one of the parties can choose to say, yes, I've discovered that the man I got married to was impotent, and so I'm choosing to leave the marriage. Yes. So, clause 43 on the name of the husband, we find it problematic, especially for the women, because it provides that the women should maintain the name of the husband, and if the woman wants to drop that name, she should talk to the husband. But these are people who have divorced. So if these two have divorced, and we are telling the woman that, you woman, if you want to leave the man's name, go to the person you fought with to give you permission to leave that name. That's quite unfair on the woman. There is no way the woman will do that. So we are proposing, the text here is, we are proposing to replace the text. One is that a spouse may choose to use the other spouse's name during subsistence of the marriage. The reason we are using gender-sensitive language here is because we've heard also from the women's movement saying, why don't men take on their wives' names? Well, it's a bit controversial, but we can solve that by just using gender-sensitive language, by saying a spouse is free to take on another spouse's name. It doesn't matter whether you're a man or woman. Second is, it's up to them. it's up to them. It's up to them. Then also we are proposing that a clause we are proposing that a clause that reads, a wife might choose to continue using the former husband's name after dissolution of the marriage. Here we are making it to be a wife's choosing, because there are women who have been, we know them because of their husband's name. The late Honorable Cecilia Ogwal, many of us never knew her name. Because Ogwal is, I think, the late husband's name. But that was her brand. Right now we have, for example, Miriam Atembe. One of us don't know her name. That's her brand. So forcing her to drop that name is so hard. But also telling her that if you want to drop that name, you must seek permission from your husband. Which husband they've divorced, they've just had a fight. Is quite unfair to them. So we think it should be a choice of the woman. Then, no person shall prevent shall prevent another person from continuing using the spouse's name after divorce. We are proposing that to be included. And no person shall compel a woman to use the husband's name. We are proposing those to be there such that it's neutral. Whoever chooses to use the other's name, it's okay. I want to skip a bit because I see my 30 minutes and I hadn't touched the other. We found it a bit hard, because what's a name? If someone doesn't want to, because legally you don't have a right of a name. My name, Peter Majela Guayaka, could be a name of 1 million other people. So if I'm going to say, don't use that name, we didn't find a legal basis for you to say, it's not like a copyright. You get? So if I said, okay, I've dropped the name Mugisha, which was your name, and tomorrow I swear I did Paul, to change to Mugisha. So you can't stop me. So we found, well, whereas some men are saying I should be able to stop the woman from using my name, really, it's hard. There are a million other people with the same name. The woman can still get married to another Mugisha. And yeah, Chairperson, I've used up my time, though I hadn't. Okay, thank you so much. Okay, thank you so much. Yeah, keep a few things. Let me go, I will skip others. Let me go to clause 74, where a irretrievable breakdown of marriage is a sole ground for dissolution of marriage. The problem we are having right now in Uganda is we've put the divorce bar so high that a number of issues like domestic violence, a woman or a man will continue under domestic violence because the divorce level is so high. We've even had situations of death or injury just because we've made it very hard for someone to divorce. Second is that I don't know if I'm allowed to tell a story, but I grew up seeing neighbors, a couple who were our neighbors, and they later divorced. So when they divorced, when I was at law school in Makerere, we studied their case. And I studied with a daughter. And we read all the details, from how the man would perform once in a while to all the other things. And then the question is, what is this mental issue we are doing to this daughter who is studying about how the father was not a good performer and that's why the mother left? And it's all coming from the fact that we have designed our divorce law to seek fault. So the party must prove that the other person is at fault, that's why I have to leave. But when these parties were coming together, we were never there. So we feel if marriage is entered into by free consent, why shouldn't it be left by free consent? If these people freely meet somewhere and say, let's get married, well and good. So let them also be given an option. So they don't need to prove that, yeah, I can no longer stand this person. Because that's what this clause means. Like you must bring proof to court that you can't stand this person, then we allow you to leave, which might bring other things. We propose that clause to be deleted. There's a clause on clause 89 on holding out as if people are married. This really is criminalizing cohabitation. And the reality is, I think 99.9% of marriages in Uganda begin as cohabitation. I don't have the statistics, I've not done the research. But when I see nearly everyone begins as cohabiting, and then they get married. So this clause which says if they live as husband and wife, it's a crime, is really going, I don't think it will ever be implemented. So we think this clause should be deleted. It's even in conflict with another clause in the same bill, which requires that where two people are living together as man and wife and they acquire property, they can petition court to give them order how to share property when they disagree. Now we have one side of the bill protecting people in a cohabitation relationship, and we have another side of the bill making it a crime. So we think that should not be the case. So quickly, yes.
Is that we will give you time.
A colleague also to submit on the part of.
I'd like to talk about the issue of matrimonial property. Oh, thanks. The issue of matrimonial property under clause 45, we have it mentioning about matrimonial property, and they talk about other properties. Of course, there's land, and then there is also other things. But this clause fails to talk about other intangible properties. For example, we have intellectual property, of which most people can acquire during their time of marriage. And some of them include patents, others include trademarks, copyright. So the question is, what will happen where we have someone who have acquired such things? So the clause should be amended, especially under subclause C, to include intangible property. And another issue which is not in this memorandum concerning matrimonial property is about where we talked about under clause, well, it's 39, we talked about conversion of marriage. And we all know that we are going to convert a marriage, for example, where we are converting a polygamous marriage to a monogamous marriage. There are circumstances where we are going to be having someone with 2 or more wives. So what happens to the other wives when you're converting? And under that clause specifically, all that is required is a declaration by 2 people in front of a magistrate. So what happens to the other women when the marriage is converted? So I think this clause should be amended also to provide for the rights of women when the marriage is converted. So, and also still under that clause 39, I also think that it shouldn't be left upon the parties who intend to convert the marriage alone to decide. Women should be also consulted on their views, because their views also matter, especially for other wives. So where we will have only one wife who is going to agree or make a declaration, what about the other women? Does their feelings matter? What about the time that they have spent in that marriage? They must have also acquired property, and some of them must have also made sure that they got the name. So what will happen to the women, the other women? So I think that should be considered.
Under clause 46, where matrimonial property is owned in common, that is on page 7 of our document, we find a number of things that have not been catered for. Where there is a polygamous marriage, how do we handle the property being owned? 2, Section 2 of the Registration of Titles Act provides that where there is a conflict between other laws and the Registration of Titles Act, the Registration of Titles Act shall prevail. Now, if property is registered differently other than being tenant in common, let me say joint tenancy, how does this bill relate with because this would mean property which is joint tenancy, you have a title, a joint tenancy title. The RTA says it's supreme above all the other laws. But this law is saying if it's jointly owned, it's tenancy in common. So you see there is going to be a conflict there, and probably this clause will be against the Registration of Titles Act. So we recommend that this clause should be aligned to the Registration of Titles, and so that we don't have a clash. Clause 47, prenuptial and postnuptial agreements. The provision is not clear on whether they apply to contracts before or after contracting the marriage. The title talks about prenuptial and postnuptial marriage, while the body only restricts itself to before marriage. So we think the body of the wording may need to be changed. Because it says where people are contemplating marriage, and yet the heading is saying prenuptial and post. So we need to provide for the post. We've provided for how we feel the clauses should be rewritten. For the interest of time, allow me skip it. It can be read later. Clause 59 on distribution of property. It says court should consider the best interest of the child, but it does not define the children here. Because the question we had, if you have a polygamous family, marriage, or you are not even in that, you have a monogamous marriage, but the man or the woman came into this marriage with another child. Let's say a man's child. So does court consider that child, who is not a child of this marriage, in deciding the property? Or does court leave that person out? The law needs to be clear. We think if court is deciding property of the man, all the children of the man, even when those children are not part of this marriage, should be considered. It's debatable, and I don't want to go into a debate with the women rights activists. It's debatable whether the same should apply for women. Like if a woman came into a marriage with a child who is not a child of the man, and they are considering the property, maybe if the property is for the woman, that child must be considered as well. Also, we think the children should also, the bill should specify that it also includes adopted children. Because if the man or the woman, if just one of the spouses adopt a child, shouldn't this child be considered in the distribution of property? We think it should. So that should be done. Then under clause 32, matrimonial proceedings should be, sorry, not 32, 62, matrimonial proceedings should be before a register of marriage. And we think the register of marriage is not competent enough for this, because under clause 32, the register of marriage is the sub-county chief, is the religious leader of different faiths. Now, let's say you have this Christian man and woman who want to divorce. And the bill is saying before you divorce, go to the registrar, who is a bishop. What are the chances that they'll get any outcome from the bishop? Because the bishop, they don't believe in divorce. So if you send them to the registrar, you are really sending them. And that's why probably all divorces should be going to court, which does not have those feelings of, in our culture, people don't divorce. In our culture, it's okay if your man has beaten you once. Let all these things go straight to court. And we are proposing the deletion of clause 62, so that any matrimonial proceedings should go to court. Then clause 73, dissolution of marriage shall be whether the parties have been mutually. Okay, this clause says property will be disputed if people have been together for about a year. And we are feeling, what if people have acquired property in 3 months after getting together? Does that mean they can't access justice? So 3 months, they've acquired property, and then they disagree. So, because the law is saying it must be after a year. So we feel this might unfairly affect some people. So before marriage, there are provisions for prenuptial. So there is a provision for prenuptial arrangement, that is before marriage. But then this one is saying, if you have mutually separated, for you to handle your property, it must be after 1 year. And we feel the 1 year is just too much. Maybe we could leave it to court to look at the circumstances, such that if the circumstances are that after a week, these people should be let go, and then court does that without us binding them. Exactly. Yes. So, Chairperson, thank you so much. That's our submission on this bill.
Thank you. Peter Wayaka. Are you from Busoga?
I'm from...
The first one is on the clause 37 in the National Marriage Register. What is happening now is that that function of marriages is completely being detached from URSB. I think they have already concluded the transfer of the function to NIRA. So if that transfer is concluded, what happens now to your proposal? Because I think that we're just left with a few amendments to the law to have it effectively transferred to NIRA. And then clause 38, you are saying we should maintain the registration of marriages, and where there is a default, that marriage will be invalid. I agree with the registration, because now everything seems to be harmonized. Registration should be emphasized, trying to bring every function in society to be registered and to be harmonized. I've been trying to get a passports for my children, and you have to get a NIN, you have to get there's something they call notification from the hospital where the child was born. The parents must have their NIN numbers. It's very tiresome, the registration everywhere. So I agree with the idea of registration, but to invalidate a marriage because it was not registered, I want you to think about that. How do we enforce it without necessarily having a marriage invalidated? And then the last one is on the young people were here and said we need to, because matrimonial causes are very expensive, especially when you talk of high court, very expensive and lengthy. And we are proposing, if there is a way we could make it easier for the indigent. They don't want to stay together. They are tired of the thing. They are tired. But when do you think of going to court? It's lengthy and expensive. So what do we do? That is clause 62, clause 62. What do we do about that? Is there a proposal you can have to make it a bit, not necessarily to, because if, again, miscarriage of justice, we must avoid it, but how do we juggle through to ensure that it is easy and a bit convenient for especially the indigent? Yes, Honorable Alan.
Thank you, Chair, for the opportunity. Let me also thank Team Deliver for the good presentation here. And you have really given us enough research, and you have guided us very well as the committee. My concern is also on clause 62, and this clause is talking about reconciliation. So when you say that whenever you get any disagreement, just go direct to the court and we should delete it. Don't you think we are going to make it very expensive? And I thought that since we went to the church or went to the cultural institution, that's where first we should go for reconciliation so that this marriage can stay, because the will of this clause is for the marriage to stay. If it fails, then that's when they can go maybe to the court. That's Chair wanted, so that he can clarify more in a way of amending this bill, amending this clause. Thank you.
For me, I just really want to commend very good presentation. I really can't wait to hear you on the sexual offenses. You've done very thorough work. I like the fact that you are awake to the times that she submitted about intangible property. I am surprised that the move of the bill did not think about that. And I totally agree with you on the issue requiring 1 year to have that as evidence of now a solid marriage. Where does the 1 year come from? Why not 6 months? Why not 2 weeks? Why not 10 years? Where did the number come from? So your research is very rich, and we will continue to address our minds to your research so that we make decisions that really inculcate all spheres. Thank you very much.
I would also like to thank the team for the detailed research that you have made on this bill. I'm so impressed, and I've learned a lot, and I think we shall mainly go by what you have submitted. I only wanted to add, when you were submitting, when you talked about some abnormalities like infertility in a man or what, to cause divorce shouldn't be encouraged to cause divorce. But I was saying also, you can also add, what about diseases like HIV? Some people divorce because they have discovered that one of the couples is HIV positive, and they divorce. So the law should also be strict on this and say this should not be the case. Thank you.
Respond to the issues that have been put to you, and we conclude.
Thank you so much, members, and thank you, Chairperson. We welcome the feedback, the positive feedback from members of the committee. Chairperson, on justice, does it mean that NIRA as a whole is under Ministry of Internal Affairs, but a department in NIRA is under Ministry of Justice? Because the bill is defining the minister to mean the Minister of Justice. The act that sets up NIRA defines the minister to be the Minister of Internal Affairs. So NIRA as a whole is under Internal Affairs. But then we are saying this department, which is dealing with marriages, is going to be under a separate ministry, despite the fact that it's in this whole thing. We find it might be a bit hard to manage, like the reporting systems, because we are putting a small department under a different ministry from like its mother. That is our concern on that. Then on clause 62, we notice the issue, the need for reconciliation. The problem is that clause 62 is designed in such a way that it's a must. You must first go before the registrar before you go to court. So it's okay if the aspect of going to before, because you see, jurisdiction under matrimonial proceedings, the registrar, a registrar of marriage or an institution of traditional, okay, I will skip those, shall be the first point of reference in matrimonial causes, which means you can't go somewhere else before you go to these ones. You can't go to court. If you go to court, me as a lawyer, I'll raise a preliminary objection and say, you should have first gone before the traditional, the head of the family. So it would be okay if this is made optional, such that if we want a reconciliation, we can go to what works. Yeah, it may, because the use of shall here means you must, if you want to divorce, first go to the, if it's customary marriage, first go to the head of the family. If things fail there, that's when you go to court. So we are making it a bit hard for that person. About matrimonial causes being expensive and how do we make it easy, it's on this basis that we are proposing faultless divorce. The reason matrimonial causes are expensive is because the parties have to prove that the other person is in a wrong. You must provide all the evidence that he's in a wrong, that's why you have to leave. But we feel if the parties came and said, come on, we've had enough, the court should be, yes, you've had enough, okay, I've confirmed. In other words, if you don't have to prove, let me say, irreparable breakdown, all you may need is swear an affidavit that I'm done with this person, which makes it affordable. And also, we can make a court, like a magistrate's court, one which can handle matrimonial properties based on the jurisdiction under the Magistrates Court Act. Because we know jurisdiction of magistrates is based on property, where if property is of a certain level that is involved in this, then the Magistrates Court Act from one man is able to handle some of these issues. Where property is a lot, then it goes to a higher court, maybe like the High Court, like it is for other cases. Then is the one on disease as a basis for divorce. Our proposal was that disease should not be a basis for void marriages. It should be a basis for voidable, like people should choose. But also disease should not be a basis for divorce. If we make faultless divorce, you don't need to come to court and say your partner has HIV, that's why you are leaving. All you need is to come to court and say, I'm fed up. What the basis for you being fed up, we don't want to know. That's why we are pushing for that kind of arrangement. Want to be divorced, that's when maybe he will need to prove some issues. But you see, let's look at this. Chair, you said we've removed emotions. Let's look at an old man and an old woman. And the two have said, the man, or one of them, or a woman has said, I've had enough. Can court say no? Because I've never seen a divorce petition that has been dismissed. Because if you dismiss it, still what happens? This person has said, I've had enough, I'm leaving. You as court, you say, okay, don't leave. But is there anything you have as court to make sure she doesn't leave? Because in reality, she will leave. Another girl, it wouldn't arise because we've proposed polygamous marriages. So if the bill is allowing polygamous marriages, it means if this man sees another young girl, he will still go anyway. Because we are saying polygamous marriages are okay. We are even saying it's possible to move from monogamous to polygamous. So,
you are assuming that the person will decide to say, I'm taking on a new one, but I'm also keeping this. We are addressing a question where they want out, but for very trivial reasons.
so and that's what would answer her question, that where the man is saying, I'm taking another one, and the woman says, I can't stand it, then she moves. So we shouldn't keep her. So property comes because as she's moving, she goes to court, which court handles the property. In terms of making it easy, the challenge we are having is that we have many people in this country who would have divorced, but some of them even go ahead and get married. But because divorce has been so hard, they actually commit the crime of those other crimes, I forget their names, just because they can't divorce. So our thinking is, if people chose to come together where we are not, we should let them choose to leave when they want to. They might agree, so of course we are not leaving out the court option. So the court option is where they disagree, then you must bring something to court to show why are you disagreeing. Because in reality, even where they disagree, these two are not going to stay together as husband and wife, even if you did an order of restitution of conjugal rights. The conjugal rights are not going to happen if one of them has said no. So it will be
that the bill is acknowledging that you can be in either monogamous or polygamous marriage. But when it comes to distribution of such property, it is silent about how you distribute such property in a polygamous setting. Because if it is one man and he has 3 wives and one wife wants out, well, how do we define matrimonial property in that context? When you look at the Kenya law, they're very clear. They give dissolution as per marriage, as per each type of marriage. So away from here, I'd really appreciate more input on that aspect, how the bill can address that.
Chairperson and committee members for allowing us to make this presentation. Chairperson, like you said, we need to address marriage separate from emotions, from religious, from cultural, because a lot of people in the community out there are suffering just because we want to force them to stay together in relationships that they don't feel they should be in. So we hope that the committee will consider some of our views and probably for the betterment of the institution of marriage generally. Thank you.
So, thank you. As I said, you have provided very interesting insights